Okay, great. Okay, well, thank you, Bob. And yeah, my name is Tom Eckerson. I direct the conservation clinic at the Levin College of Law at the University of Florida. And it is what we call an experiential or service learning program where students work under my supervision for clients, among them the Florida Springs Institute. And it accomplishes two primary goals. One is service to the conservation community writ large. And then the second is learning, where students are able to gain some experience in professional practice before graduating. And so real pleased with that. We have two students with us today who will be presenting, Courtney Meyer and Phil Sliger. Before I introduce them, I'll just mention a couple things. Please keep your mute button on unless you're going to speak. And then any questions you have, put them in the chat and we will take them as they come in once we've concluded with the presentation, and I'll moderate that. We will end at 11 for the purposes of people who wish to leave, but if there's folks who want to stick around and chat a little bit, I think we all have a little bit of time thereafter. So our two students are Courtney Meyer and Phil Sliger, and Courtney is a third-year law student, which means she's finishing up. She's in our environmental land use and real estate law certificate program. She's on the Florida Law Review as the articles editor, which is a fairly prestigious position. She has an undergraduate degree in business from the University of Florida. And upon graduation, and even before, because she's doing what we call a semester in practice, she'll be working for Judge Timothy Corrigan in the Middle District of Florida in Jacksonville. And last but not least, Courtney is an avid water woman. She is a wakeboarder and was on the UF national team in wakeboarding. So I suspect clean water is particularly important to her because she's probably drank her share. Phil Sliger is a second-year law student. He's also in our certificate program. He's a member of the Florida Journal of Law and Public Policy, a specialty journal that we host. He also has his undergraduate degree in business from the University of Miami at Ohio. He'll be working this summer in his second summer with the Gunster Law Firm in Orlando. He's also the chair of our Public Interest Environmental Conference, which will take place virtually this year, February 12th and 13th. The theme for that is Just Transitions for a Sustainable and Just Future. If you're interested in the conference, and many of you have probably attended it in years past, you can find more information at ufpiec.org. So with that in mind, I'm going to turn it over. But before I do that, I'll just mention one thing, which is interesting. This is a talk on Florida water law and analysis. And what is particularly compelling to me is the tradition and the legacy of the University of Florida and its College of Law, particularly in developing and expanding Florida water law. And you'll hear a little bit about that as we move through it. Many of you will know some of the people who have done the work in this arena from their participation in the community as well. So I'm going to turn it over now to Phil and Courtney and talk to you guys later.
All right, thanks, Tom. And just before I get started, I want to confirm, and if you guys can just thumbs up that my screen is showing up for you. You're looking at a title slide here. Okay, perfect. Before we get started, I just want to give everyone a quick roadmap of what we'll be covering today. So our presentation will be focused on the public interest test as it pertains to consumptive use permits in Florida water law. So in examining this test and how it's currently applied, we'll begin by first looking at the test's historical origins in Florida water law. We will then look at how the term the public interest is used, defined, and applied throughout Florida law and in other environmental statutes. We will then revisit the public interest test used for consumptive use permitting and examine how it's been applied by the regulatory agencies and how it's been interpreted by the courts. And finally, we will wrap up with some conclusions and recommendations and some Q&A. One thing to note up front, the focus of this project was on consumptive use permitting specifically within the context of outstanding Florida springs. As such, our analysis was limited in scope to the 4 water management districts with outstanding Florida springs in their jurisdiction, which will help explain when we get to that portion of the presentation why the South Florida Water Management District is not represented. So here's the specific public interest test that we'll be focusing on today. This can be found in Chapter 373223 of Florida statutes. And this is the 3-pronged test that is used to determine whether a permit will be approved or denied. We'll be focusing in on the 3rd prong of this test, the requirement that a proposed consumptive use be consistent with the public interest. And we'll seek to understand what this means in the context of water use permitting. However, in order to understand what consistent with the public interest means in prong 3 of the analysis, we must contend with the fact that the same phrase is part of the definition of reasonable beneficial use, which is a requirement for prong 1 of the analysis. So it is worth taking a quick step back here to see why this apparent redundancy exists. So the term reasonable beneficial use has its origins in Florida water law. It was coined by the former dean of the University of Florida College of Law, Frank Maloney, when he helped develop Florida's model water code in the early 70s. This model water code was adopted nearly in its entirety by the legislature when it passed the Florida Water Resources Act of 1972, which has now become Chapter 373 Florida statutes. Prior to the development of the Model Water Code, there were 2 legal doctrines that formed the basis of water use in the United States. In the Western states where water was scarce, you had the beneficial test. The Western states followed the tenet of first in time, first in right, meaning that the first person who put a water to a beneficial use acquired superior right to later appropriations of the water, emphasis being on use for a beneficial purpose. In the eastern United States, where water was in abundance, you had the reasonable use tests, which focused on whether the use itself was reasonable. The reasonable use doctrine at common law often applied to riparian owners, so those individuals whose property contains or is adjacent to a water course. So as Florida began to boom in population, as water resources became more and more scarce, Dean Maloney and his fellow authors of the Model Water Code sought to develop a test that retained the best of both the East and West approaches. That gives us the reasonable beneficial use test that exists in Chapter 373 today. This combination of East and West approaches may help explain why Dean Maloney felt the need to include consistent with the public interest in the definition for reasonable beneficial use, since much of the reasonable use doctrinal system was focused on riparian landowners and not the public at large. It's likely that Dean Maloney thought it important to include an explicit consideration of the public interest so that the reasonable beneficial use wouldn't be construed too narrowly for the purposes of the Model Water Code. So that may help explain why consistent with the public interest exists in 2 different prongs of the consumptive use permitting analysis. That said, it doesn't quite make clear what it means for a consumptive use of water to be consistent with the public interest. However, examining the declaration of policy that's found at the beginning of the Model Water Code can give some clues as to what at least Dean Maloney felt should be considered. The policy declared that the Model Water Code should be liberally interpreted to obtain the maximum beneficial use of waters for domestic uses, irrigation, power, development, mining, and industrial uses. However, it also indicated that adequate provision should be made for fish and wildlife, public recreation, maintenance of proper ecological balance and scenic beauty, and the preservation and enhancement of waters of the state for navigation, public recreation, municipal uses, and public water supply. Dean Maloney declared that these latter objectives were in the public interest. Ultimately, this policy language was not included by the legislature when it enacted the Florida Water Resources Act in 1972, leaving us with the current statute that requires this seemingly redundant assessment of the public interest and a term consistent with the public interest that lacks clarity and it lacks definition. So to try and get a sense for what the public interest means in Chapter 373223, we started by looking at where and how the term public interest is used elsewhere in Florida law, beginning with the Florida Constitution, which includes 3 distinct references to the public interest. The first being the requirement that the governor address the state annually and recommend measures in the public interest. The other 2 references deal with sovereign submerged lands and declare that the sale of sovereignty lands may be authorized only when in the public interest, and that the use of sovereignty lands be authorized only when not contrary to the public interest. So these references are not too helpful in defining the term, but it does highlight an important contour of how the public interest is defined or used in Florida statutes. And that is the 4 different standards that you see here: clearly in the public interest, in the public interest, consistent with the public interest, and not contrary to the public interest. While the exact distinction between these 4 standards is not quite clear, the hierarchy of the standards is apparent, with clearly in the public interest posing the highest bar for a permit applicant to meet, and not contrary to the public interest posing the lowest. So moving on to the Sovereign Submerged Lands Act found in Chapter 253, we get 23 references to the public interest. The chapter doesn't provide a definition of the term, but the context of its uses does give some clues as to what the legislature intended it to encompass. In some instances, the statute broadly predetermines certain activities, such as aquaculture, to be in the public interest. In those instances, the legislature has drawn its own conclusion. And in those instances, there can be no further balancing to determine whether or not those activities are in the public interest. Throughout the rest of the statute, the term public interest is used to relate to environmental, social, and economic interests. This intent was made clear enough to the Florida Department of Environmental Protection, who, in interpreting Chapter 253, set forth its own definition of the public interest that included demonstrable environmental, social, and economic benefits which would accrue to the public at large. So it's easy to see how the language of DEP's rules mirror the intent of the statute. The Environmental Control Statute, Chapter 403, which provides authority to Department of Environmental Protection for activities relating to things like pollution, facility siting, and water supply, uses the term public interest 21 times, but again, provides no clear definition of what it means. However, DEP, in promulgating rules to interpret the statute, devised several detailed factor balancing tests by which the department must assess the public interests. For instance, with regards to anti-degradation permits, the public interest test includes 4 factors to balance, including whether the proposed project is important and is beneficial to the public health, safety, or welfare, and whether it will adversely affect conservation of fish and wildlife, water-based recreational values, and marine productivity. So despite the authorizing statute not defining the public interest, FDEP was able to devise a workable test and assess the public interest as it was required to do so. So the last statute we'll look at is in a different part of the water resources chapter that we find the consumptive use requirements. Again, this statute does not set forth a definition of the public interest, but it does provide perhaps the most comprehensive guidance on how agencies should assess the public interest, with the inclusion of the detailed factor balancing test you see here. So the statute provides that in determining whether an activity which is on or over surface waters and wetlands is either not contrary to the public interest or is clearly in the public interest, the governing board of departments shall consider and balance the following criteria, these 7 factors. The clear enumeration of these factors left the Department of Environmental Protection very little discretion when it was interpreting the statute, and in fact, the agency adopted this factor test verbatim when promulgating rules for the issuance of environmental resource permits. Further, when these permits have been challenged and made it in front of the court, courts have had very little trouble articulating their decisions based on this enumerated factor balancing test. So to summarize, the term public interest is used very liberally throughout Florida law. It's used in a variety of different contexts, and the legislature has provided varying levels of specificity as to its meaning. In each of the statutes we explored, the legislator provided some level of guidance to agencies interpreting the statute, enough guidance that those agencies were able to either incorporate the language of the statute into their rules, or were able to create their own more concrete definition or factor balancing test that provides clarity as to the term's meaning. So with that historical and legislative background, I will hand it over to Courtney to talk about the public interest test in part 2 of Florida water law dealing with consumptive uses.
Hi, everyone. As Phil and Professor Ankerson mentioned, my name is Courtney, and I'm going to kind of walk us through how the public interest test stands in Florida water law as it relates to consumptive use permits. And I wanted to start by just kind of asking generally, like, where could the public interest be defined or by whom? And we have a couple of options here. So the first being, we could define it in Chapter 373. That's probably the most obvious one. We see it in a few of the environmental permit and in a few of the other environmental laws, but it's not very common. But our other options are FDEP could define it in its state water policy. While FDEP rules are not necessarily binding on the districts, many of the districts do adopt the FDEP rules and the language used in FDEP rules. Another option is the water management districts create their own rules through the administrative process, and those are binding on the districts, and that's another option. And the final option is the water management district applicant handbooks. The applicant handbooks are adopted by the water management districts, and they enforce those rules, but their primary purpose is to really help applicants kind of weigh their permit, whether their permit is going to be valid or not. And it's supposed to give guidance on what the requirements of the statute are. And so in our opinion, we think the public interest is best defined in the handbooks, but we're going to kind of walk through all of these options and kind of where it stands now. All right, Phil, next slide. So coming back to this slide, this is, as Phil mentioned, this is chapter 373-223. And we end up with this confusion because reasonable beneficial use is defined in 373-019 as part of its definition is being consistent with the public interest. But we also have this third prong consistent with the public interest. And we end up seeing a kind of conflation between the two standards because they are the same standard and we have no separate definitions for each prong. Arguably, there should be a different definition for each prong because the legislator laid out a 3-prong test, meaning 3 different considerations. But as you'll see, we don't really have much guidance as to how we should differentiate these 2 tests. Okay, Phil, next slide. So first, we could adopt rules within FDEP or within the water management districts. Currently, FDEP 6240 does not have any definition of the public interest. It does, however, have a very detailed list of what the reasonable beneficial use test should be. And that's interesting because they could have adopted the same thing with the public interest test, but they decided not to. And then for the water management districts, they currently do not have any rules that define the public interest, but they do provide reservations. So a reservation, for example, one from Northwest reads, the governing board finds that consumptive withdrawals of surface water from the main stem of the Apalachicola River are not in the public interest and therefore reserves from use by permit the flows specified in the subsections. So these kind of examples, several of the water management districts have them, and it essentially just says these water bodies are off limits. Except Northwest also provides a little bit more guidance. Phil, next slide. And they say that new and expanded uses of the Floridian aquifer system for golf courses, recreation, or landscape irrigation, or other non-potable uses are determined not to be consistent with the public interest. So that's interesting because Northwest, while it doesn't define the public interest, it just gives us a little tidbit into what it might mean, what essentially isn't in the public interest, but it's still very narrow circumstances. Okay, Phil. So now we're going to move into the handbooks. And as I said, these are binding as rules and each water management district creates their own. So they could create a public interest test that is tailored to what they need. So in Swanee River, the public interest is defined as the broad-based interests and concerns that are collectively shared by the members of a community or residents of the district or the state. Great. So they define the public interest, but it's very, very broad and it's not really clear as to what it would mean or how it could apply. It's also not clear if this is defining the public interest as used in the first prong or as used in the third prong. It could be both, it could be either. Again, we run into that kind of conflation problem and it's just not clear. Swanee is unique in that it also has a separate definition in the context of water bottling. It has a factor test that includes 11 factors, but it's used for both reasonable, beneficial, and public interest. So it says, in determining whether a proposed beverage processing use is reasonable, beneficial, and consistent with the public interest, the governing board will consider the following information. And some of the factors include whether there's a need for the water, the location of the beverage and processing facility, and general plans and existing land uses. All sounds very great. Again, they kind of conflate that reasonable, beneficial, and public interest, but it does provide a very detailed factor test. Unfortunately, it again is also in very limited circumstances. Okay, Phil. St. John's also has a definition of the public interest, and it's defined as those rights and claims on behalf of people in general. Again, very broad. We're not sure if it applies to the reasonable beneficial test or the public interest test found in the third prong of 373223, but it's a definition. It's something. Okay, Phil. Southwest Florida is the only one that we find that truly had nothing on the public interest. The phrase is mentioned several times in the handbook, but it's only in the context of explaining the actual language of 373223. It doesn't give us any guidance on how the public interest should be defined or labeled. Okay. Finally, we have Northwest Florida. And in Northwest Florida's handbook, there is no definition of the public interest. But again, they have this kind of interesting caveat that says the use of groundwater to augment surface waters during times of drought, normal climatic variability, or for purely aesthetic purposes is generally not consistent with the public interest. It's interesting because that gives us a little bit of information on what isn't in the public interest. Aesthetic uses, golf courses, fountains outside of restaurants, things like that. But no definition of what the public interest is. Okay, Phil. Next, I'm going to kind of start us off on how the public interest test is applied. We saw in the handbooks and the rules, we really don't have much of a definition. So it's not surprising that sometimes it seems like courts and water management districts have a hard time kind of applying this test. And so the first case we found was in the 5th District Court of Appeal, and the court held that in the context of the third prong public interest test, you must consider whether the water use is efficient, whether there is a need for the water requested, and whether there is a use for a legitimate purpose. That's interesting because the court phrases the holding in a way that it is just repeating what is already being done, which it's interesting because if the court was interpreting 373223, that could arguably be binding on the water management districts, on other water management districts, outside the context of the permit challenge, excuse me. But the way the court phrases the holding, we're not really sure if it is binding on other water management districts. Okay, Phil. We found a couple other DOA cases. DOA is the Department of Administrative Hearings, and it's where all the cases are held if you are challenging a permit or a consumptive use permit. And in the DOA cases, all of them were in the context of St. John's River Water Management District permit challenges. But kind of the general themes we found were the two public interest tests in prong 1 under reasonable beneficial use and under the third prong are not the same. They're intended to be differently. They're intended to be applied differently. And second, we found that economics is not a part of 373223. Again, interesting. I'm not sure it applies anywhere outside the context of St. John's, but it is something to note. And finally, one thing I found interesting was when I was looking through the case law, I found a couple of permit challenges that were older in Southwest Florida Water Management District. And the rule challenges were all to rules trying to define how evaluators should determine permits are valid or not. And some of them were just narrowing in very specific contexts, but others were definitions of the public interest. And these rules were challenged, and eventually the petitioners won. The rule was overturned. So maybe that's why water management districts aren't defining the public interest, because they're afraid that they're going to get overturned for kind of overstepping their bounds. Okay, Phil.
Okay, so in addition to looking to the case law to try and find an interpretation of the public interest test, we also looked to examine how that three-prong test, which was set forth in Chapter 373 and adopted by the districts through their handbooks, was being interpreted and applied when the districts actually issue or deny permits. Again, quick caveat on our empirical analysis here, it does only include the 4 water management districts with outstanding Florida Springs in their jurisdiction. To talk about our process here, we visited each of the water management districts' public permitting portal and downloaded all of the water use permit applications that were decided between October 5th, 2000 and October 5th, 2020. We started by taking just a random sampling of the permits and exploring the technical staff reports to see if there was any discussion of the public interest that informed the district's decision, and quickly determined that that was a rather ineffective and efficient way to find that analysis. So instead, we decided to look at just the permit denials that had been issued by the districts. The idea being that if a permit was denied on the basis of not being consistent with the public interest, those staff reports might tell us something useful about how that analysis was conducted and what factors were being weighed. Also, as you will see, by only looking at the denials, we were dealing with a much more narrow set of data. What you see on the screen here is data from the Suwannee River Water Management District over the course of 20 years. There were 3,352 permits approved, just 7 denied and 62 withdrawn. In St. John's, just over 8,500 permits approved, 55 denied and 239 withdrawn. In Southwest Florida, just over 7,000 approved, 118 denied and over 1,500 withdrawn. And then in Northwest Florida, just shy of 2,000 approved, 80 denied, and 23 withdrawn. A quick note on the difference between a substantive and administrative denial. This is not defined equally across the different districts. Some districts do use those terms to say something is a substantive denial or something is an administrative denial. What typically falls under the category of an administrative denial is some sort of technicality. Either there's missing information from the application, or the district was unable to reach the applicant and denied it on that basis. The substantive denials actually deal with, as it sounds, the substance or the merit of the application itself and how that stacks up against the district's criteria. Now, this may seem like an extremely stark contrast between approvals and denials, and it certainly was to us. However, I'll add an important caveat here, which is that we don't have any insight really into how the permits were negotiated. While the public permit documents sometimes included correspondence between the district and the applicant, that information was not always available or was not always insightful. So it very well may be the case that a large proportion of permits are approved because the district was able to express its concern early in the process. The applicant was able to course correct and make sure that the application that they submitted adhered to the district's rules, or that the applicant saw that their application was going to be denied and therefore withdrew it. Nevertheless, we explored the technical staff reports for all of the substantive denials, looking for any discussion of the public interest that formed the basis of those denials. Only a handful provided any discussion of the public interest, and most of those that did reference the public interest in the context of the reasonable beneficial prong of the 3-part analysis, as opposed to the standalone consistent with the public interest requirement in prong 3. There were 2 substantive denials in St. John's Water Management District that are rather older, but that were denied because the applicant's proposed use of water was solely for aesthetic purposes, and the district deemed that not to be in the public interest. However, I'll note that an older version of the St. John's Handbook contained a rule stating that the pulling of water solely for aesthetic purposes was not in the public interest, similar to the rule that Northwest still retains. However, that criteria has since been removed from the St. John's Handbook. Thus, at the end of our analysis, we were still left with an extremely vague understanding of how the water management districts are actually interpreting and applying Chapter 373223, and what kind of analysis they actually conduct when determining whether or not a permit is consistent with the public interest. I think most importantly, through all of our analysis of all the denials in the past 20 years, we only came across those 2 permits that were denied on the basis of the public interest test found in the 3rd prong of Chapter 373223.
Hi everyone again. I'm going to get us started on kind of just big picture conclusions. We're going to walk through a few possible kind of challenges to this issue, and then end with a little bit of a kind of guidance we would give on the public interest test in the future. Okay, Phil. So this is what we end up with. This shows the 4 water management districts and where the public interest is defined. It could be defined in 373223. As we saw, it's never defined in 373223. If that was the case, it would be yes for all of those. Water management districts do not define the public interest in their rules, except Northwest has that kind of caveat to the aesthetic uses. So that's why I put partially in there. And then defined in the handbook, we have vague definitions in both Suwannee and St. John's. We have no definition in Southwest. And we have that weird caveat again in Northwest, but we don't really have a definition. And then for case law, we have some definition from St. John's, but other than that, we do not have a definition of public interest. Okay, Phil. Okay, so here's a few challenges that we thought about that could be brought against the water management districts or the legislature for failing to define the public interest. The first is non-delegation. So non-delegation comes from constitutional law and administrative law, and it essentially says the legislature is not allowed to give away its legislative power. It kind of stems from the separation of powers principles. Agencies fall under the executive branch, so they have to keep their executive power, not legislative power. In this circumstance, we could argue that the public interest is such a broad term that it is arguably asking for legislative action, because they're asking the water management districts to define everything as it relates to this very broad term. Non-delegation was always thought of as a dying doctrine, especially on the federal level. It's recently seen a resurgence in the state level. Michigan Supreme Court recently overturned a case that emergency was too broad. The word emergency was too broad to delegate to an agency, and that it needed to be defined further in the legislature. Our second argument could be that the water management district's actions were arbitrary and capricious, either because they aren't defining the public interest or that they aren't applying the test that they have or applying 373223. Now, I think that's their best argument. Agencies have to explain their reasons on the record. And in this case, because in all of our denials, we could not find a discussion of the public interest, or in most of our denials, that is arguably arbitrary and capricious. Now, in this case, that would overturn an agency action, and they would have to ideally remedy the situation. We could just explain on the record what their reasoning is. As we said before, we do have a few definitions of the public interest. So if the water management districts talked about their application of that test, that would not be arbitrary and capricious, but that's really what we're looking for. Finally, we could petition to initiate rulemaking. In that case, the agency can decide, the water management districts in this case could decide that they don't want to initiate rulemaking, they don't want to define public interest, and that's fine. They just have to explain their reasons for denying this petition to initiate rulemaking. If they approve the petition, then they would have to go through the rulemaking process, ideally to define the public interest. Okay, Phil.
Perfect. So Courtney just highlighted several sort of points of entry for a challenge to the current public interest test. We believe that regardless of who takes up the mantle, whether it's the districts, FDEP, or the legislature, the 3rd prong of Chapter 373223's consumptive use test needs to be defined so as to clearly articulate the interests that are being weighed by the district in making these decisions. It's our belief that the process should be carried out by the water management districts, where a transparent and participatory rulemaking process would allow for the public at large to have their interests represented. Beyond the actual process to be used for defining the public interest, we believe the district should draw upon public interest tests that exist elsewhere in Florida statutes, as well as those used in other states for regulating water resources, and should seek to develop a uniform factor balancing test like the one we saw in Chapter 373414 that would reduce subjectivity and discretion. Such an endeavor should lead the districts to develop a test that not only considers the impact on the water resources, but also on the health, the safety, and general welfare of the public, Further, a primary policy objective for Chapter 373 is the sustainable management of water resources. Therefore, any public interest test should seek to meet that objective and should meet the present reasonable beneficial needs without compromising the ability of future generations to do the same. So the work of devising a public interest test does not need to begin from scratch. Up on the screen, we've included a few factors that we believe achieve several of the goals that I just discussed. You may recognize some of these factors from Dean Maloney's policy statement to the Model Water Code. Other factors here seek to achieve requirements of Chapter 373 that require the departments and governing boards to take into account cumulative impacts on the water resources and to manage the water resources in a sustainable way. Again, we've put these up here, but I'll reiterate that we believe any public interest test should be the result of a transparent and participatory process that incorporates the public interests. So finally, we'll end with a quote from Ryan Smart, Executive Director of the Florida Springs Council, who stated that the implementation of the public interest test levels the playing field between the highly motivated private interests and the dispersed public good. I think in the context of our presentation and the current public interest test that's applied for consumptive use permitting, we might begin to seriously question whether or not the playing field is currently balanced. And with that, that concludes our presentation. I believe we can open things up for some question and answer.
Okay, can you hear me, Phil and Courtney? Yeah, so that's great. And just so you know, there's a through line from Dean Maloney all the way to Ryan Smart, and it all involves the University of Florida, and we're very pleased with that. There's a number of questions that have come in through the chat. I'm going to sort of selectively take them one at a time. Some are more responses or comments than questions, and I'll try and filter through those as well. And there's more streaming in right now. But the first one to kind of warm us up is a fairly technical one, which we may not know the exact answer to, but David Kaplan asks when the Northwest Florida Water Management District promulgated its rules dealing with finding things not consistent with the public interest as a matter of law, if you will.
Yeah, I saw that one in the chat. I do not know off the top of my head. I could find it out. And the agencies keep pretty good, or the Water Management District keeps pretty good records of their rules. They only go back to a certain year though, and I'm not sure what year that is, but I just know it's in the final rule right now. So it is enforceable at the moment.
Great, thank you, Courtney. And so there's been a couple questions about bottling permits. I think that's appropriate. Whether these are ever in the public interest, I think, is probably the tenor of the questions. And maybe Phil, you and Courtney could discuss that and a little bit about what you know about public interest and bottling permits.
I can start with this one. So water bottling permits, it's hard. They're definitely harder than a lot of other ones. So think of probably our other biggest entity pulling water is agriculture. So agriculture is arguably more in the public interest than like water bottling, because most of that is staying within our local economy. It's helping local towns, etc. Whereas water bottling, often the water is taken and shipped across state lines, etc. That feels a little less in the public interest, but saying that they're never in the public interest is probably not accurate. Well, it can't be, because water bottling in the past has been approved, and not all of them are invalid. It's just we'd love a little bit more consideration towards the water resources and things like that.
And Courtney, didn't the Suwannee River actually promulgate some specific rules regarding how it would look at water bottling permits from the public interest perspective, or reasonable beneficial use?
Yes. So Suwannee River has a factor test in its handbook, specific in the water bottling context, and it applies to both the reasonable beneficial and the public interest test. So it kind of takes those first and third prongs together. And I mentioned earlier, it requires them to look at the need for the requested amount of water, the location of the withdrawal, the location of the beveraging process processing facility, the plan to convey water from the withdrawal facility to beverage processing facility, a site plan, existing land use and zoning designations, a market analysis, schedule for completion of the construction of the beverage processing facility, contractual obligations, other evidence of physical and financial ability to process the requested amount of water, and other documentation necessary to complete the application. I think the only thing we think is missing from that is the impact on the water resource. Is the water resource impaired? Is it meeting its minimum flow levels? Is it taken from an area that is hurting or is high for tourism? Things like that.
Yeah, I think an additional challenge with the water bottling, as Courtney mentioned, the benefit of water bottling isn't always felt in the immediate vicinity from where the water is withdrawn. And it brings up a challenge that I won't pretend to know the answer to of what the scope of the public should be, and how broad that is defined geographically, whether it focuses in on the immediate area and community surrounding where the withdrawal takes place, or if it should be drawn more broadly than that, or if it should be dependent on the specific use.
Okay, and so there's another question here, which I think warrants maybe going back a slide, Phil, in your case, at the end. It says, would you say that the 19,000 plus letters written to the Suwannee River Water Management District is a reflection of the public interest? Maybe if you went back to your recommendations of the test, you might find something there that refers to that. I guess we're not sharing the slide anymore.
Is it showing up now? Might have accidentally paused it.
It's all right.
Can you see that?
I can't.
I'll try and bring that back up. I'm not sure where my thing went. Let me just do.
I wouldn't belabor it. It's nice to see at least some people's faces as well. Here it comes.
Okay. So, that's not something we included on this particular slide, but one idea we did play around with in defining a public interest test was some sort of requirement for the districts to respond to public comment. And if they are going to issue a permit that flies in the face of thousands or hundreds or even just dozens of public comments that go contrary to that decision, requiring the districts to publish a statement along with the other public permitting documents that explains that reasoning and justifies it, and at least forces them to sort of stand by that decision that seems to, as you mentioned, fly in the face of significant public opinion.
Well, and it might go to that last bullet you have there, the shared interest of the members of the surrounding committee. 19,000 is a lot of letters. It's one way to think about that. And in federal law, they summarize all the comments that come in rulemaking. So I just point that out. The staff and the agencies do that, and then those are published with the rule. Here's a question from Merrill E. on Willie Springs. And I think Courtney's looked at this one as to the denial, which you want to explain that, Courtney, as you recall it?
Sure. Yeah. So Lily Springs was one of those cases where it was denied, but they could continue and resubmit their permit, and Lily Springs ended up being withdrawn. So it was not under our denials. That was one of those circumstances. Yes, the public interest was considered, and it was a good denial in our opinion, but it didn't come up under our substantive denials because it was later withdrawn instead of denied fully. Does that make sense? So that is definitely an issue with our research process. It was really hard to kind of figure out all those kind of caveats, and even the withdrawals were really too many to wade through.
Yeah, and I think it goes to the point that we didn't have really visibility into how these permits are negotiated or the correspondence that's going on. But I think it strengthens the proposal that there needs to be an enumerated factor test so that analysis is transparent, so that applicants know exactly what's being considered, and we don't have to guess at what perhaps internal conversations between the district and an applicant are actually dealing with, but that those interests that are being weighed are readily apparent to everybody, not just the applicant and the district, but the public at large as well.
Yeah, and then I think this is for you as well, Phil. I think it's are many of the denials deemed denied because the application was not filled out correctly, and that goes to the pie charts, correct?
Yeah, and sometimes it was difficult to determine what exactly the basis of the denial was. Some of them explicitly said in there, you would see an email saying, we haven't been able to reach the applicant for the last several months, and so they've denied it on that basis. Others were missing information that didn't permit the district to do a particular analysis as to whether it met certain criteria. The 22, I believe, that we considered substantive denials were ones where there was at least enough information to say, okay, they're looking at the substance of the application, weighing it against the criteria that they use, and it didn't meet that high bar.
Great, thanks. And then Lucinda has a question here. With the legal emphasis on the public interest, how does the emphasis mesh with the importance of natural systems, natural communities such as OF, outstanding Florida Springs, and the Floridan Aquifer? Is public interest mainly defined when viewing water as a commodity, or are there cases where restoration, preservation, protection of natural systems is deemed to be in the public interest?
It's a great question, and I think it's something that would need to be sort of weeded out in the process of going through the rulemaking process and defining the public interest. I will say, emphasize again that Chapter 373 does have as a primary policy objective the sustainable management of the water resources, and includes explicit references to the protection of fish and wildlife and conservation efforts. And so that's clearly a paramount policy objective of the authorizing statute. And as such, we would recommend those to be sort of primary focuses of any public interest test.
And I might note here, just sort of occurred to me, but outstanding Florida Springs are a defined class of water body, much like outstanding Florida waters. In many cases, they are both. And in cases of permitting, some aspects of permitting, the demonstration has to be made that something is clearly in the public interest when you will affect an outstanding Florida water. So maybe that's a way also to carve out special consideration for that category of springs. Here's a good question. What does the process of revising the handbook look like? Can the public initiate that? Courtney, do you want to take that?
Yes, I can. I know Phil will also is deep in Florida civil procedure right now, or administrative law. So I'm sure he will take this too. So it works just like you would a rule.
Does that mean you have an exam coming up?
I think Phil does.
Yes, I do.
So because the water management district handbooks are like rules, they are revised like rules. Phil, you want to take that further into more detail?
Well, so exactly. And so the administrative process, I think the most straightforward way to go about it would have someone file a petition to initiate rulemaking. And so as Courtney sort of walked through, the districts would have to respond to that petition, either by initiating rulemaking on the issue that the petition covers, or by filing a response saying, here's why we are not going to initiate rulemaking as you suggest. And so if they do decline to initiate rulemaking, they at least have to go on wax and explain why it's not necessary. And that could be a good statement to force the districts to have to make. Further, that statement would then go up to the legislative committee with governance over that. So it would actually go to the legislature to sort of review that statement and the merits of it. And so I think it's a good way to put pressure on the districts to either further define and clarify the public interest in the third prong, or to come out and go on the record of saying why they're not interested in doing so.
And here's another question for either of you. Do MFLs, that is minimum flows and levels, influence the public interest?
I think we believe that they should. I think, given our empirical analysis and the approvals and denials that we saw, it's not apparent that the implementation of minimum flow levels has impacted the issuance of permits in any meaningful capacity. Again, we lack some insight into the withdrawals and the negotiations going on, but it doesn't seem like after the implementation of MFLs, there's been a significant increase in permits denied on that basis.
To just build off that, there is also a definition. I mentioned earlier how FDEP had a rule defining or giving a factor test for reasonable beneficial, and how most of the water management districts have adopted that. In that factor test, one of the factors is in accordance with any minimum flow or level and implementation strategy established. So it is considered under reasonable beneficial, what includes that sort of public interest test, but it's not specifically under the third prong public interest test.
Great. The questions are coming in and comments faster than I can even read them, let alone we can answer them. So I suspect what we're going to need to do ultimately is collate these and try and answer those in some fashion thereafter, and send that to the Springs Institute for further distribution. But I'll keep going here. Mary Jane Angelo, who's one of the authors of Modernizing Florida Water Law, one of those articles that you'll see referred that are part of the legacy of the College of Law in particular, notes that there's case law under the public interest test in another section of the statute, 373-414, that limits the factors to, and says that they have to relate to the water resources, so that economics and public safety cannot be considered. So that's a good persuasive argument as well.
And just a comment on that, I think that is the product of having a well-defined factor-based test that makes it very clear what's in scope and what's out of scope. And having read some of those cases as well, I think the judge in interpreting that had no problem being able to say these economic interests are clearly out of scope.
And here's a very good question that Bob Palmer will appreciate. Were any water management district or DEP staff interviewed to help get information on how the public interest is assessed? Bob's always trying to get the students to make phone calls, something that seems to be a product of the last century, not this one. So let's try him on this one.
We did make several attempts. I know I did, and Courtney did as well, to get in touch with some individuals, unsuccessfully. And I will say that was fairly early on in the process, when I don't know that I would have known enough about this to do an effective interview. So it may not have been a bad thing, but I think it would be interesting to engage them on this, and that they may have something to say contrary to our assessment.
Yeah, and this was a long and difficult project to take on in a semester, so that remains to be done, I guess. Some of that kind of analysis. From Bob Knight, would non-delegation or arbitrary and capricious challenge go to DOA or, I guess, or question mark? Go ahead.
Yeah, non-delegation would go to the courts. So the state courts, because you're challenging a legislative action. Arbitrary and capricious would go to DOA because you're challenging an agency action.
Okay. Let's see. Marcia Danielson asked, this may be a little bit too technical question to answer here, but how many factors are considered in the bottled water permits in the public interest?
For Swanee specifically, there are 11 factors. Past that, we don't have anything else.
Okay, well, here's something that we talked about throughout, and again, it's Professor Angelo. The water management districts would argue that all of the factors you are proposing are already addressed in the detailed criteria for reasonable beneficial use.
That's a very valid argument, in my opinion. Certainly, reasonable beneficial has a pretty extensive definition and factor tests. My one response would be that even if that is the case, I would like more consideration of that. We saw some responses we saw some discussions on the reasonable beneficial use test, more so than the public interest test, but it was still minimal because those denials were not just denials on the public interest, they were all substantive denials, and there were still so few of them. And then further, while the factors may be considered under the reasonable beneficial use test, I would ask why the legislature has public interest used twice then. If you intended us to conflate them, why would you make them 3 separate prongs?
Yeah, and just to add to that, it may be that the substance of the reasonable beneficial use does contain all the factors we need to assess the public interest, and what we'd be arguing for is really just a better organization of that information in a way that makes it easily understandable what interests are being weighed when assessing the public interest. As it currently stands now, the public interest test in prong 3 being so broad and vague and untransparent as to what's actually being balanced really provides some legal and political cover to the agencies who are applying it, because the public at large isn't able to have any insight into what's being balanced. And we feel like that should be more transparent. In the current way that it's set up with this conflation of reasonable, beneficial, and consistent with the public interest makes it really difficult to, as Courtney and I will say, looking through the technical staff reports, understand where they're, what they're actually considering and which prong it's going to.
And fortuitously, I guess, Richard Owen, who agrees with you. He's a former staffer at the Southwest Florida Water Management District for 30 years and 7 years with, I'm not going to get what this initialization is. I think this is a fascinating topic and agree with your recommendations for further transparent discussions and development of better public interest criteria. So there's an inside staffer telling you what it is that he agrees. So I think that's good. Yes, you can get copies of the slides. I think what we're going to do here is, well, we still got another minute or two, so we'll ask, let's see if there's some more questions here. A lot of it's comments at this point. Yeah, it's mostly just comments. Oh, here's the last question. My question was, how are any factors considered in the bottled water permits for the public interest? So we're back to that. And I guess we'll conclude with that, and then we can quit sharing. And if people want to take off, they can, and we can open it up for discussion and from there on.
Courtney, I'll let you follow up on this, but I personally think calling the water bottling factor test a public interest test is a bit of a misnomer and potentially problematic, in that it does consider so many economic interests, and many of the factors really don't seem to apply to the benefits of the public at large. But Courtney, I'll let you weigh in.
Yeah, sorry about that. I guess I didn't answer the direct question last time, and that's my fault. But I guess it also is a reflection of the fact that my guess is as good as yours. So unfortunately, we have these factors, but again, when we looked at all of the substantive denials and the Lily Springs denial, that's all we had. That's all we know is how they apply the public interest test. So we don't really know how they always apply them. Again, as Phil said, it's a little problematic because they mostly consider economic interest. So arguably it's not a good public interest test, but it's all we have.
Yeah, and so here's what I think will make a concluding comment, because I think it's a good one, and there's some agreement on that, and that's perhaps we collectively define the public interest and start using our definition in meetings and correspondence. I assume we means the Springs Council. Perhaps this will help encourage them to define. So that is a way to do it. And when you seek rulemaking, you will probably could introduce that as your in your petition if you were to do that. So with that in mind, I guess there's still plenty of people here. Do you want to go for, if you guys ready to go for a few more minutes, Courtney and Phil?
Happy to.
Okay, maybe raise your hands. I can't see all the screens, but or what do you want to do, Bob? How do you want to handle a group discussion with 60 people?
I have no idea, Tom.
Probably the best way, this is Brenda, is to have people continue to type their questions into the chat box.
Okay.
And if they want to be unmuted, they can, I can unmute each person individually.
Okay, that's good. So let's do it that way. And I'll go back to the chat box, and we'll go for another 15 more minutes and then reassess here. These students do have exams coming up, and so I don't want to take too much of their time. They've been working hard on this in the midst of exams, I might add as well. Here's something, let's see. Most of it's comments now. So any questions? Here's one. Any plans to look at state preemption on local governments adopting fertilizer sales bans? I think that's a bit out of the scope of this discussion, so we'll leave that for now.
No plans right now, but there are future clinic students.
Yeah, I mean, I think we're sort of done unless there's, oh wait, there's some new ones coming in. Lucinda Merritt has a comment on state preemption. Do you want to let her in, Brenda, to make her comment?
Yeah. Lou, see if you can unmute yourself now. Maybe not.
Well, while you're doing that, here's a question. Can any bottle permits be revoked? I don't know that we looked at the revocation of permits. I think they would have to be for good cause or something like that. Did you guys?
I did not look into the revocation. I did see several permits that were permit renewals that were denied because of poor conduct or conduct that didn't adhere to the permit criteria. But I didn't come across anything where a permit was revoked before its renewal date came up.
Yeah, on that, again, I'm not an expert on this. We didn't focus on this area, but from what I remember, if at any time the conditions are not met, it can be revoked, but I doubt that would ever happen outside of renewal, / I don't know if it can happen outside of a renewal.
Yeah, I mean, there would have to be good cause would be my guess. And there's a bit of a property right issue there once it's been once a permit's been granted. Let's see, Lucinda is unmuted. Do you want to speak, Lucinda?
Yeah, can you hear me?
Yes.
Okay, I just wanted to comment about the state preemption. The rights of nature people down in the Orlando area had filed a lawsuit challenging the state preemption against enacting local rights of nature laws. I don't know how that affects state preemption elsewhere, but they are trying to challenge the whole idea of state preemption based on the fact that they think it's unconstitutional. And the other thing I wanted to say is I love Stacy's idea of having us collectively say what we think the public interest is. And I think there's an out of balance thing here in that the rights of natural systems are not being stressed as strongly as rights for people. And I was really interested in the idea of public interest, public trust. So I wanted to thank you all for this presentation. It's been very helpful to me and to help me understand. Thanks very much.
Great, great. So from Jim Tatum, why is it that our outstanding Florida waterway designation with its strong and clear language has no teeth for protection? Outstanding Florida waters, I assume that you're thinking about. And again, that's something that not a part of this project in particular, but we did write a white paper on outstanding Florida waters, and I could refer you to that, which is I think if you just Google my last name and outstanding Florida waters, you'll come up with a rather detailed one that I and several PhD students worked on a number of years ago about the legal framework for those. I think, Bob, should we let it go? I mean, it seems like.
Looked like Bob Knight wanted to engage in some dialogue. Maybe he could be unmuted.
Isn't that a dangerous proposition?
Yeah, of course it is.
Can you hear me?
Yeah.
Am I coming through? Yeah, I like the fact that the students made a recommendation in terms of the arbitrary and capricious being a method of the best method, the preferred method of actually strengthening the public interest test. But I commented that Courtney indicated that DOA would be the responsible legal entity to do that. And we have really bad experience with them in terms of finding anything that is not in the interest of the for-profit industries. And of course, they not only rule the legislature, they rule the agencies because of the appointments at the highest levels. So it seems like the circuit court approach would be a better way to go. And you said the non-delegation approach would go through the circuit courts, I believe. And the petition to initiate rulemaking is just something that apparently anybody can do to a water management district. But once again, they're controlled, in my opinion, by the for-profit industries. So I would just like a little more discussion from the fantastic brains that are in these students' heads, and yours, Tom, of really what is the best approach, because we're way past the point of critical. This needs to be dealt with. We just can't go on studying it forever and watching our water resources be depleted and destroyed. So that's all I had to say.
Well, this is Tom here. I don't have an instant answer for you on that. It seems to me that, the petition for rulemaking is the weakest of the three, but it also is in some ways the easiest, and it gets it front and center, and you can appeal from those as well. So that's one thought I had. The non-delegation doctrine is attractive, and we'd have to research it a lot more because there's a lot of case law involved there. I've been involved in one non-delegation case, which we lost, which was a water case. But it was on interdistrict transfers of water between Osceola and Brevard County at the beginning of my career when I was same age as Courtney and Phil. And but the loss of that case resulted in change to the statutes. So that's also something that happens. You bring a case and then you lose, but you get the legislature's attention. Of course, the times are different. So I guess I don't have a clear answer for you, and we'd have to think it through a lot further. And this white paper is the first step for you on that, is the way I would say it.
Yeah, and there's always an option if you don't like DOA's decision. You can appeal to the state courts. That's how Marion County v. Green got there. So.
Yeah. Well, I think what I'd like to do is let these guys go and go back to their schoolwork. But I thank everyone for coming. It was a great crowd, and we're real pleased with it. I think one of the things that Phil and Courtney brought to the table that we often don't see is the ability to do the data analytics, to mine that data. I think it's their business degree background that helped quite a bit. And quite frankly, the availability of information, of data is good in Florida. I mean, they were able to get all the permits and do that analysis, that empirical analysis, which helps to inform. Now know how few permits are denied. And that in itself is sort of interesting. What we don't know is what's in the heads of the people who are approving them and how much negotiation goes on. And that's one reason to have a more explicit test, so that they have to articulate that test in a way that can be understood and challenged if need be. So I'll leave it at that, and thank everyone for coming, and thank all of you for the hard work you do, those that are involved with the Springs Council and the Springs Institute. And we will go through the chat and look at the questions, I imagine, and see if we missed anything, but I think we got most of it all. So thank you very much. And Courtney, Phil, take care.
Thank you all. Appreciate it.
Thank you all.